threshold, functionaries, allegations, deviating, impeachment, asymmetrical, misbehavior, gratification. We know that we are living in post-truth world when prayers for investigation or inquiry are thrown out summarily at the threshold by constitutional functionaries, stating that the allegations are not proved, conveniently ignoring that inquiry or investigation is sought to apply the specialized tools and agencies at the disposal of state to discover facts, to justify or falsify the allegations. Such instances force one to redefine inquiry and investigation, deviating from its commonly understood meanings. The order passed by the chairman of Rajya Sabha rejecting the impeachment motion moved against Chief Justice of India, though not surprising, is confounding because of its asymmetrical reasons. Asymmetrical because the reasons are either upside down, allegations are not proved, so no inquiry, or circular, like placing reference on a judgment passed by a Chief Justice of India led bench in a case which was alleged to have been improperly dealt with by the Chief Justice of India so as to justify Chief Justice of India. The premise of the rejection order is that the draft motion failed to establish proved misbehavior on the part of Chief Justice of India. The test applied by the chairman, as clear from paragraph 5 of the order, is as follows. At the stage of admission, I have to apply a test that if every statement stated in the petition is believed to be true, would it still amount to a case of proved misbehavior within the scope of Article 124(4) of the Constitution of India. Proved misbehavior is an expression clearly distinguishable from misconduct, as is apparent from the language of Article 124(4). The intent, gravity and onus are of a much higher degree. The prefix proved places an obligation of actually proving the misbehavior before the parliamentary procedure can come into play. The motion was rejected because of its failure to meet the test employed by the chairman of bringing out proved misbehavior. This test employed by the chairman is fundamentally flawed. Proved misbehavior is a term in Article 124(4) of the Constitution of India, which states that a judge of the Supreme Court can be removed from office only by an order of the President on the ground of proved misbehavior or incapacity. For the President to order removal, the impeachment motion should be supported by 2/3 majority of both the houses of Parliament present and voting. The stage for such proceedings had not reached in the instant case. The chairman committed a grave error by leapfrogging to Article 124(4), oblivious of his role and mandate. As per Article 124(5), Parliament can enact law to regulate the procedure for investigation and proof of misbehavior or incapacity of a judge. Judges Inquiry Act 1964 is the law enacted as per Article 124(5). The chairman is merely a statutory authority under Judges Inquiry Act. As per Section 3, if a motion for impeachment is endorsed by at least 50 members of the Rajya Sabha, then the role of chairman begins and he has to decide whether to admit the motion or reject it. The Judges Inquiry Act does not have any test of proved misbehavior. The Act is intended only to regulate the procedure for investigation and proof of misbehavior or incapacity of a judge, going by its preamble. The Judges Inquiry Act is therefore largely procedural, and the Rajya Sabha chairman is only a statutory authority who has to act within the contours of the procedural legislation. Hence, the role of Rajya Sabha chairman is very limited, and he cannot sit in judgment over the merits of the allegations. The chairman's role is limited to making a preliminary scrutiny of the complaint to see if there is a prima facie case to refer it to the committee for investigation. The actual investigation is to be carried out by the committee constituted under the Act, and the actual decision regarding impeachment has to be taken by the Parliament based on the findings written by the committee. That being the scheme of Article 124(4) of the Constitution of India and the Act enacted as per 124(5), the chairman acting as a delegate under the Act cannot import the test of proved misbehavior while deciding whether to admit the motion. The test of proved misbehavior is reserved for use of the President at the stage of proceedings under Article 124(4) for deciding whether to remove the judge from office. It is not for the chairman to apply this test while acting under the Judges Inquiry Act. Hence, the chairman misdirected himself by employing a test which is totally alien to the proceedings under the Judges Inquiry Act. The reference made to the decision in a case law in 2010 is out of context. That was a decision regarding removal of members from the State Public Service Commission, and the passing remarks made there have no relevance here. The chairman put the cart before the horse by burdening the members with actually proving the misbehavior for admission of motion. Further, on the basis of use of tentative phrases in the draft motion like Chief Justice of India may have been involved in conspiracy of paying illegal gratification, the chairman held that the members who signed the motion were unsure of their own case.